Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warnings. Let's get started.
Life, Loss and Legacy, a planning solo podcast for people in the first few years after their bereavement. My name's Jordan Varker. I'm an independent financial planner with Planning Solo, and I'm joined today by Gillian Miranzi from Scanlan, Carroll Lawyers. Gillian, hello.
Hello. Thank you for having me, Jordan.
Not at all. I'll quickly read your bio and then we'll learn a little bit more about you. Gillian is an associate at Scanlan, Carroll Lawyers, where she practices in estate planning and deceased estates. Gillian has presented on various topics regarding wills and estates, including will drafting, family provision claims, and powers of attorney. Gillian is passionate and advocates for her clients in other areas of law, including commercial and debt recovery. And Gillian, some of the conversations we've had have been fascinating, and hopefully we'll touch on a few of those topics like that. The longest running estate you've ever had, which blew me away. But thank you for coming on to this podcast today. We are talking today about probate, demystifying probate, what it means for people as they're navigating that process. But before we do, could you please just tell us a little bit about yourself besides all the work stuff?
All the work stuff. Well, yeah, my life pretty much is my work, but I do get away. So myself, I love basketball. So I play sometimes 3 times a week, and I'm a very, very sporty person. My family, we're into footy, netball, basketball. So, I just absolutely love sport. If you don't find me working, I'm either doing Pilates, basketball, gym, or watching my brothers play footy.
Holy, yeah, that's pretty fast. 3 times a week with work on top. That is, cuts off. That's commitment.
Yeah, it's a lot, but I love it. I absolutely love it. But then apart from that, it's just me and my family. I like to chill. I like to go to the beach. I'm a very,
And I think I'm going to speculate. If you're anything like me, working in an area as serious as what you do work in, I imagine that off time is really critical.
100%. So sometimes in the thick of it, it's nice to think that, I can work the whole 9 to 5, but sometimes there's cases that just stay with you and it makes you worry and keeps you up all night. So if I just go do, for example, 1 class of Pilates, that clears my mind. It helps me actually think about the importance of it keeps my anxiety at bay. And be like, I can actually do this tomorrow. It helps you clear your mind. It releases really good endorphins.
I think it's worth flagging as well, because I think for 2 reasons. I mean, when we were doing the family law stuff, I had that picture in my mind of the horrible family lawyer, and I think that's maybe the horrible estate litigator as well in people's minds. But at the end of the day, these are people doing a job, and they're helping people navigate a really difficult time, and that often blows back on them. So I think that's something that we should all just flag and respect. But also for people that we're talking to in this podcast, it is completely normal for it to become overwhelming. So have methods and things you can do to try to release that pressure because, a lot of this stuff isn't pleasant and you've got a lot of emotional weight to it and you still need to go through it. So look after yourself, everybody, I suppose, is the theme there. But to hop back onto what we're talking about today, we are discussing probate. And in particular, I want to cover off sort of 3 big areas. What is probate and why do we have it? The actual mechanics of probate, so how does it work? And then also just tips and traps for executors and administrators that are going through that probate process, because I believe sometimes it can be quite drawn out. So we might hop straight into it without further ado. Let's have a chat about probate. So can you walk us through a definition of probate?
Yeah, no worries. So probate, when I explain to clients when they come see me for the first time and they have no idea what probate is, what I like to say is it's a certificate that's granted by the Supreme Court of Australia that allows you to call in the assets of a deceased estate. Calling just pretty much means to handle the assets. So close bank accounts, sell property or transfer property, sell cars, sell shares, for example. So that's what that certificate allows you to do. That certificate on it will recognize you as the legal executor of that deceased estate, and it gives you that authority to deal with these asset holders such as banks and real estate agents.
So until the point that certificate is granted, is a will essentially just a couple of bits of paper?
So no. So what happens? A will is actually a very, very strong document. So let's say someone you know has passed away, and you've gone and located the will, and you know that you're the executor. You, from that day, have so much responsibility that takes place, whether you're legally recognized or whether you have that certificate or whether you're not. So it's your responsibility now to start acting as an executor of the estate. So now you need to start actually applying to get a grant of probate. And that process itself usually involves going to visit a solicitor, and that solicitor will prepare what you call a probate application, and they'll sit down with you and they'll go through all the assets and liabilities of the deceased estate. And then afterwards, then you get the certificate, and then you go off and you call in those assets. But for example, if you don't have that grant and you just have that will, it still gives you legal authority to act as executor, but you might have tenants in a property of a deceased estate, and you might not get probate until later on down the track for whatever reason. So a will definitely is not just a piece of paper. It gives you a lot of legal authority.
So even on its own, even in that period until probate is granted, you still got a little, quite a lot of power through the will itself.
Correct. That's right. So long as you have the death certificate to show that the person's actually died, you're not going rogue, going around showing.
Because I was thinking, okay, well, what if somebody says somebody's dead? So yes, you definitely need the death certificate. Right.
You definitely need the death certificate, and then if you get your will certified copy, it is enough to get the ball rolling, but it's not enough to keep it going. So after a while, you might communicate to a bank, this person's passed away and we need to pay for the funeral. So generally, a bank will allow you to access the deceased bank accounts to pay funeral expenses. So you can rock up with the death certificate and certified copy of the will, and they'll allow that. But then the assets are frozen. You can't access it again. They'll want a grant.
I think we've talked in previous episodes that banks can kind of get some sticky fingers around that time as well. They can try to start washing off debts with accounts and things like that. So you need to act fairly quickly and fairly carefully around the probate side.
Correct.
Is it required to get probate every single time somebody passes away? Sorry, that sounds like people pass away multiple times. No. For every person that passes away, does their estate then need to get probate?
No, so probate's only required if the deceased had assets over $50,000 in their sole name. That's the only time we'd recommend getting probate. Otherwise, a death certificate and that certified copy of the will is actually sufficient.
So a common one there, you said in sole name. So if a husband and wife own a home together?
Yep. So husband and wife own a home together, then there's what we call the laws of survivorship. So it just automatically passes to the survivor. So what's really important is when someone passes away is knowing what assets they held and how they held them. So if they held them jointly with their partner, then yes, it doesn't form part of probate. It automatically passes to that survivor. If they held it solely, then yes, it forms part of probate. But then it can get a little bit complex. It's easier said than done. The easiest assets are probably a bank account, cars, shares. Most people just hold those in their sole names. But then it can get tricky if the person was a director of a company or there's family trusts involved, because there might be an appointor, and it's like, oh, well, then does that form part of their probate application? But no, it's separate. And superannuation also doesn't form part of probate as well. That's a very separate set of laws as well. So always get legal advice. And it's not always straightforward. You say one thing, oh yeah, everything in their sole name except for this, 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 and this.
Every episode I've recorded, it has been kind of the message to be, make sure you get specialist advice, because this stuff's really difficult, because there is no black and white. Like everything, there's always some sort of exception involved with it.
Okay.
You mentioned, and I want to just run down this little sort of sidetrack briefly. You mentioned if somebody's part of a family trust or part of a company, you've got an appointor. Now, some of the people listening might have all of a sudden inherited kind of this exposure to a family trust or a company. So can we very, very quickly just address the appointor and what that role is? Because I don't think a lot of people realise how important that is.
Correct, that's right. So a lot of people do have family trusts, and you're absolutely correct. There's the appointor and there's the trustee. The best way I can explain it is the person that controls the family trust is the appointor. They have all the power. So what's really important is when a client comes to me and they say, mum or dad were part of this family trust, and they may not know. That's understandable. That's usually how people speak. They were part of this family trust. So the first thing you say is, I want to see the trustee, because you need to see who the appointor is. Usually it will be that mum or dad. And then the next step is to read the trustee to see what happens on the death of the appointor. So that's why these documents are very important. A lot of people will say, oh, the trust was created in 1982 by the grandparents, you know. And then we don't know where the original deed is. Why does it matter anyway? We're getting our distributions. No, it's true. It's a very, very important document. And if the appointor dies, and let's say no one knows what's happening, usually the executor steps into the role of the appointor in the interim. So until, you read the trust deed and see whether, if they're allowed to, or who's supposed to be next. And if you go and see a will specialist, in the drafting of your will, you should appoint who the next appointor is in your will. So that's usually how it works. I think people get confused between appointor and trustee. Yes. So a trustee is usually a company. Most of the time, not always. Most of the time, people create a company to be the trustee. And the best way I can describe it is, a trustee just does the day-to-day stuff of the trust. So, they'll sign off on the taxation returns. They'll go see an accountant. They'll make the distributions. But the power, the control, rests in the appointor.
Because they're the ones that can nominate who the trustee will be, and they can remove the trustee. Yeah. And they may all be the same person in some cases, but that's not always the case. And I imagine where things go wrong is where there's ambiguity, where documents are lost, where things get a bit confusing. So the takeaway for me is definitely, I've been guilty of this in the past, that all those company documents you get and all those trustees, they kind of just fold away and whatever, they kind of sit in a box. They are really important, and you need to make sure they're protected, and make sure they're somewhere safe, because that will be the roadmap for anything that happens. Is the trust deed is critical, and the same thing applies to self-managed super, but the appointor role is obviously far less, I think, transparent. Self-managed super is very complex. Get somebody else. Get specialist advice.
Different set of laws, but yes, that's right. And you raised a very good point then. I cannot agree yet. I couldn't agree more. The appointor can get rid of the trustee. The trustee cannot get rid of the appointor. And so it's very important that when someone passes away, that someone goes and sees a lawyer so they can explain these terms and what they mean. And unfortunately, we find ourselves, I've had clients in the past where they're executor of an estate, and their mother, father, brother, sister, whoever, was appointor of their family trust. And unfortunately, they were also joint appointor with maybe their ex-partner. So now the executor has been appointed as appointor, because that's what is said in the will. So it might be their brother or sister, child. And now they're dealing with an ex-spouse. And that ex-spouse obviously does not want to get off, the whole family trustee, because they're getting distributions as well. It'll affect their rights. It's, very, very sad circumstance, and it's a costly expense as well. So you'd want to get it right the first go.
We had Lucy Percy on an early episode, and she said something that's always stuck with me since. She said, your will and your arrangements are the final act of love you're leaving for your people you leave behind. And I think having it mapped out properly, it helps avoid a lot of that extra heartache that they don't necessarily need to take on. To bring it back to the probate piece, you mentioned the Supreme Court. Are the rules for probate the same around the country?
No, so it's a state jurisdiction, probate. So Victoria's laws are different to New South Wales laws and South Australian laws. So each country is different. So I've been dabbling a bit in South Australian probate, just for fun, on top of my extracurricular activity. I've been doing. But their probate process is completely different. So, for example, here in Australia, in Victoria, someone will come and say, they had a property, let's say in Kew, so our office space. So they have a property in Kew, and you say, okay, go and get an appraisal. So they just go get an appraisal, and roughly we put in the value of that in our probate application. In South Australia, you actually have to have a full valuation, and it has to be attached to the probate application. And it has to be
valuation.
Correct, and it has to be submitted to the court. So the rules vary. Here in Victoria, we have to advertise. So advertising is the first step in getting a grant of probate. So advertising is pretty much you as executor come and say, it's my intention to obtain a grant of probate for the deceased estate of XYZ. Once you advertise, you have to wait 14 days. And that's the period that any creditors who are owed money by the deceased estate can come forward during that time. And they'll be included as a liability on the estate. In all my time doing probate, I've done a lot of probate. It's only happened one time, and it was a government agency.
There's someone sitting there in Canberra going through those ads. Where is that advertising? Where's that advertising done?
So that's done on the Supreme Court website. Okay. It's called Redcrest. It's not easy, I guess, for someone who is trying to do it themselves to do. I mean, you can certainly be done, but most people would hire a lawyer or engage a lawyer to do that. So you wait the 14 days, and then once that's done, then you prepare your probate application. In South Australia, you don't have to advertise. You just straight prepare the probate application. So it's definitely much so a state jurisdiction.
Are the thresholds the same, that $50,000 threshold? Is that consistent, or is that different as well?
That's different as well. Yeah, it's different. So it really depends on the state where you are. And you have to be very, very careful, because you might have someone that lived here in Victoria, but all their assets may be in South Australia or in Queensland. And so let's say they have property in Victoria and they have property in Queensland. You have to get a grant of probate wherever. So you can get a grant of probate in Queensland or in Victoria. So let's say you get one in Victoria. And then you can't use our grant to go and sell the property in Queensland. You're now going to go and have to go to a Queensland lawyer, and they have to reseal the probate, which means the Queensland court's going to look at it, and if appropriate, then they'll put the Queensland stamp on it, and then you can go and sell that property. Yeah, so you have to be very careful.
That's school, right. Like we have federation because the train lines were different, like the gauge of the train lines. Like that's why we federated as a nation. It's like, well, I don't know if we are fully federated if we're doing stuff like that. Because I imagine then that's a new probate application. Like you can't just hand in the old one. You have to do a brand new one, and then that would be on their paperwork, subject to their requirements.
Correct, and that's happened in New South Wales as well. We had a deceased estate where he had 2 properties in New South Wales, and they engaged a lawyer and they said, we just have to do the application again. They copied our application, don't get me wrong, because the assets
but it's still got to be copied across.
Exactly right.
Requirements. Oh, man. One of my questions later on is, how does somebody do this themselves? I think we're answering that pretty quickly. Looking at the thresholds, because I'm just thinking through a scenario where somebody passes away in Victoria, but they own $45,000 of something in Queensland. You know, probate's not required there, but they've got a house here. Like, oh man, yeah, just.
It gets messy. It gets very, very messy. And even if someone comes down and says, "Oh, can you help us look after this one property that Dad held here that he's tenanted out?" It will be, well, we've got to reseal the grant. You have to get a Victorian Supreme Court stamp on it. Yeah.
So I think one of the questions for a lot of people going through this, and they always say, oh, probate's taking ages, or probate's this, probate's that. And we just presume that we know what probate is. I'm curious, and this is quite a big question. Why do we have probate?
That's a very good question. Why not? Why not just deal with it on our own?
Yeah, like why does it go through the court, I suppose,
Yeah, I think having that limit of 50,000, I think allows a little bit of structure and a little bit of order. So once it goes through the court, so the law itself is called the Administration and Probate Act, and that governs everything that we have to do in terms of, you know, from obtaining to administering the estate, to finalising the estate. Really, really good set of rules, you know, just sets it out. Going through the court really helps in terms of, for example, if you have someone that goes out and they might not necessarily understand the law. And probate itself is quite tricky because I think you mentioned before, banks are the biggest hurdle I think people will have to get through. And with the rise in scams and with the rise with the way people are, I think it's just a really foolproof, safe-proof way to make sure that this certificate, which is granted by the court, so they've recognized you legally as the right standing person to administer this deceased person's estate, it holds a lot of weight. Otherwise, we would have random people going everywhere with people's wills.
Yeah, you're right.
Yeah,
There's
and
no
saying,
arbiter then, is there? Like you could have three people present three different wills. If we don't have a method of formally accepting which one's the valid one,
correct,
that'd be
correct. That's
chaos.
right, and that's chaos. And the thing about it, which is very interesting, and I think it's a very good system in how we do it here in Victoria, is that the court thoroughly looks at the will, they look at the death certificate, and they make inquiries. So if the deceased will was dated, let's say today's the 13th of April, so let's say it was dated the 11th of April, and the deceased had brain cancer and they died today, that's questionable. They'll say, did they have capacity? If not, this is the courts. The courts ask these questions because they want to make sure that this person's last wishes are respected, but also that there's nothing untoward happening as well. So because people can become greedy, unfortunately, and that's the truth of it. That is the truth of it. Yeah, so it's a process.
We'll be talking with somebody else on a future one about family provision claims and things like that around disputes. But when probate is granted, does that make a family provision claim or any sort of claim against the estate harder or invalid because the court has kind of signed off on it?
No, not at all. You can bring a family provision claim anytime within 6 months of probate being granted.
And that's different in Victoria again, isn't it? Like that again, that's a state by state.
It's a state by state. That's right, because the act itself is state legislation. So yeah, it'd be different.
Of course it would be. But
yeah, Australia, it is 6 months. I know that much, but the other states, I'm not too sure.
So the court granting probate is not them saying yes, we fully accept and will accept no challenge against this will. They're just saying that yes, we accept this is the last will and testament of the deceased.
Correct. That's right. That's right. So they're not. That's right. They're not accepting that. Oh, this is the last will, so there's no challenge. This is it, and distribute in accordance with the beneficiaries. That's the aim. But if someone makes a claim, they have 6 months from that grant to make a claim against the estate, because now the estate's established. Because now there's an acting executor. Yeah, so they can bring a claim.
So that's an interesting point there. Just, I mean, for me, I guess it's more of a semantic thing that's interesting. But so the estate doesn't exist until the executor's appointed. Is that what you mean?
So there's an estate. Don't get me wrong. Someone passes away, and then they have their estate. Whether someone's got probate or not. You've got your bank accounts, you've got your cars. That's your estate. That's what's made up of assets you have in your sole name. That's your estate. What I'm trying to say is when someone is suing your estate, they have to sue a legal representative of your estate. So they can't sue you. You've passed away. They can't say, oh, you owe me money. Someone has to stand in that position. So therefore now you have an executor who stood in that position, and then you can sue their estate.
And that role isn't formalised until probate's finalised.
Correct. That's right. I had a student ask me the other day, do you always have to act as an executor? So if you're appointed in a will, does that mean you have to act? And the answer is actually no, you don't have to act as an executor. And sometimes there's been times where we've had an insolvent estate. So the person had more liabilities than assets. And it's really important to note that when you accept the role of executor, you're accepting all responsibility to do with that estate. And it's also a personal responsibility. So if someone has a liability, you as executor are now, if the state can't cover it, you'll be personally liable to pay that liability. So, and that's the term, and that's the facts of insolvent estate. So you don't always have to act just because, I'm executor, I have to do it. But that means, are you going to take on all these liabilities as well?
And plus all the work that goes around that as well.
Correct.
The final question I have kind of around what probate is and why do we have it. What happens when there's no will?
So it's called intestacy. So that's the word. So you've died without a will. So which then obviously means there's no executor. So who's going to stand up? And same act, state legislation says it's the next of kin. And there's a hierarchy for next of kin. So it usually goes spouses or partners. And then it usually goes children. And then it can even be parents and grandparents, cousins. It goes down, siblings even. So it goes down the list. But most top of the list is spouses.
You've just prompted a conversation I had with some people yesterday. They live here. Their whole family's overseas. they have 2 young kids, and they're having trouble finding a guardian. Now, I know this is a very big topic, but does that kind of hierarchy approach apply to guardianship, or is there more flexibility for the court to find somebody in the event both parties pass away?
When both parties pass away, okay. When both parties pass away, it does kind of play into the guardianship aspect of it for the next of kin. So what usually happens is if both of them pass away, let's say a car crash or airplane, it's usually the youngest one that comes into effect, the youngest of the two, of the partners. So if they've passed away, then you take, is there a spouse? No, they've passed away as well. Then you go down, is there an adult child? No, and you keep going down the hierarchy. Is there a sibling? Yes. Is the sibling able to look after the child? Yeah.
Yep. And that's, yeah.
But that's another reason why to have a will. You want that written down.
Another very good advertisement for expert advice. Don't do this on the post office will. Like, get expert advice. You need the expertise.
Oh my goodness! I have a story about that. Yes, I have a story about post office wills. Interestingly enough, this is a very good example, and a family trust. It's everything going on in this.
They did a post office will with an estate with a family trust in it.
No. So what happened? Yeah, no. Thank goodness. I think I would have fit that day. No. So I was looking for an original will for a client, and their brother is the executor, appointed executor on the will. And then I saw the will, and the first thing I saw was a post office will. And it was the first thing. It's almost disrespectful. No. I'm in a post office will. And I remember I was having the conversation with the client, and he goes to me, "Oh, is this going to be an issue?" And I said, "No. Look, the thing is, using that example I said before, where the will was done and the person has brain cancer. This is the circumstances where we had. So it was a post office will. Had brain cancer, the deceased, close in the timing, the dates of making the will, and that's right, and the death."
Which I should jump in there and say, that's quite common. Like, that's normal if you have a terminal illness, but it does make things more difficult afterwards because extra questions are going to be asked. That's all.
Extra questions are going to be asked by the court, as I said before. So because he's gone off and done this on his own, I can already guess the questions that the court are going to ask. So I've never, just as a general, rule of thumb, I've never been able to get a post office will probated on the first go. So I submit it to the Supreme Court, and the Supreme Court will always come back with questions. Or they say it wasn't executed properly, or explain why the deceased handwriting is shaky. There's all these questions that arise out of it. So on the first go, I have never been able to get a post office will through.
Which is valuable to flag that Supreme Court process. That's not a rubber stamp. They interrogate the document.
That's right. Exactly right. They make inquiries. They really look at it. So I looked at our client and I said, "Look, I'm going to be honest," and I told him that I never have, and I can probably tell you that we're not going to get this through on the first go. And the first thing they're going to want to see is a certificate of capacity. So,
which
and the issue is,
really, aren't they?
That's right. So we can get medical evidence. I don't know if he had capacity though. That's different because he's gone off and done his own will on his own. And if you went to a lawyer, they would advise you of these things. If you have any medical illnesses, they'll tell you, "Oh, this is the impact it will have on your will. It's probably best you go see a doctor for X, Y, Z reasons, for these reasons as well, to make sure that this is what you wanted." I can't do this in this case because he's done it on his own. So then there's an issue because I can't do this. And he goes, "Well, what happens if the court just doesn't accept it?" And then I go, "Well, it actually goes to their last valid will, which was made in 2008 or something." That's right. If they hold that there's an invalid will, it'll just go to the next one, which is, 2008. And that will appointed his ex-spouse. That's right. And it made her appointer of the family trust.
Is that how it played out?
No, I'm just letting him know what's gonna, what might happen.
I think that implicit in that is each will, to be valid, I believe, it has to revoke all previous wills. So if this post office one is not valid, then that previous will is not revoked, so it goes back to that one.
Correct. That's right. That's right. So yeah, so post office wills are a don't. If there's one thing anyone takes away from me today is please do not make a post office will. It is worth spending that couple 100,000 just to
Or a couple of hundred
yeah.
or 1,000.
Or not 100,000, sorry, a couple hundred.
Gillian's rates are enormous.
I mean, people complain about lawyers' fees anyway, so
What's a couple of extra zeros?
exactly.
So people listening that might find that really insensitive because they just got the bill yesterday.
Well,
But okay, so if there's no will, then we fall into can we still get probate if there's no will?
so it's a different process and it's called letters of administration. So it follows the same process. So you still advertise saying XYZ has passed away and, it's your intention as next of kin instead of being executor appointed under the will to apply for letters of administration. Same thing, you still present the deceased assets and liabilities and it has to be over 50,000 in their sole name. So that still applies. And then once the Supreme Court has granted letters of administration, you're now known as the administrator. So instead of being an executor, your role is administrator of the estate. And then it's exactly the same process after that. You can go to a bank, you can go sell property. There's no difference. The only difference is there's no will.
Is it faster to get a letters of administration through than probate? Because they're not interrogating anything.
Correct, that's right. And the court doesn't have to review the will. They don't have to review anything. It's just the death certificate. The quickest we've had is the next day.
Wow. Okay.
Yeah. So it's so much more quicker because they don't have to make inquiries. It's just a death certificate and the person's passed. And you do an affidavit explaining why you're the next of kin. So, I was married to them, they were my spouse, or I'm their most adult child because their spouse passed away, mum and dad, so situation.
What happens? I mean, I assume and I hope that they're very rare, but in the really tragic case where somebody dies and they are completely alone, no family, no friends, no will, what happens to the estate? Does that go to the government, unclaimed money? How does that play out?
Yes, I don't know where this rumor started from, but the amount of people that say to me, "Oh, I don't have a will, so is the government going to take on my money?"
Yeah, they say that about super
I
as well.
don't. Yeah, people say about super. I don't know who started that rumor. They need to be, prosecuted because spreading false information. No. So it will actually they'll try to find someone. The government will take it, but it's the absolute last resort.
Yep.
So they will go down like if you have siblings, nieces, nephews, cousins. Surely there's someone that can step in. I haven't had a situation where, there's no will and someone doesn't have anyone. I've had the opposite where people actually generally with no family usually make a will because they want to donate to charity or give to whoever, a friend in their life. So that's usually I find more the opposite happens. But if you didn't have any family, that it will go down that list. They will surely find someone.
And what happens? I mean, I'm running a bit off track here. I'm sort of running down a rabbit hole. But what happens if an executor they have like an estate, and in that estate is a specific bequest to an individual person, and that person just cannot be found?
Oh, okay. That's happened before, actually. Yes.
We had David
Yes.
Packett on another episode, and he said people have been dying for a very long time, so if you can think of it, it has happened, and we have rules around it.
Correct. No, that's absolutely right. There is rules for every circumstance, every single even like how I was saying next of kin, your spouse is a first. It even says multiple partners. It is equal. You're all equal. Then it gets.
It allows for
between.
polyamory in the rules. Holy dooly, I didn't know
Correct.
that. Okay.
Yeah. So if you have multiple partners, it'll get split equally, whether they know about each other or not. It happens. Everything's happened. Everything's happened.
Yep.
But going specifically to your question, which was
sorry, I'm going all over the place. But the idea that I'm an executor, I have an estate, I'm trying to settle the estate, and I've been left. The will says I want to give $10,000 to X, Y, Z. And despite all my best intentions, I just cannot find X, Y, Z. I cannot find anyone related to X, Y, Z. They've disappeared into the ether. What do I do with that $10,000?
Yeah, no worries. So you have to show that you've made reasonable inquiries. So, for example, if you can't find them now, but then later on in 10 years' time, they show up because they've heard somewhere that their great aunt Betty left them $10,000. They're here to collect and it's no longer there. You have to be able to show that I looked for you on Facebook, I telephoned, I even went to the coroner's court. You really, really try to make efforts. If not, and then what would happen with that $10,000 is it can form part of the residuary estate, but the beneficiaries have to agree though as well. So as an executor, you just have to say to the beneficiaries, look, there was this 10,000 I was unable to locate. Maybe one of the beneficiaries know. Hold it. I'd hold it and isolate it for a reasonable period of time, just in case. I wouldn't just do a week search where you've tried for 1 week straight and then be like, no, can't find them. And then it'll form part of the residuary estate as long as you've made reasonable efforts. But it's important for the executor to know or administrator to know you are personally liable. So if they come back in 10 years' time and they say, I want my $10,000,
and you haven't made reasonable inquiries and you can't document that and you can't substantiate that, then you may be on the hook for $10,000.
That's right.
Now, estates have to keep records and they have to do tax returns, don't they?
Correct.
Would you have to keep the estate open for that period where you can't find that person and do the tax returns and keep things rolling?
Yeah. So what usually happens, so I mentioned that, if someone has to bring a claim, to have a 6-month period. As an executor, you do not have to keep any money for whatever reason after that 6-month period if you've properly administered the estate. So in that 6 months, let's say you've attended to everything and everything is liquidated. Let's say in the 4th month, you keep it for 2 months until you reach that 6-month period, and you can, make it earn interest, and then you distribute to the beneficiaries if they're all there, let's say. So with that 10,000, during that 6-month period, you should be making reasonable inquiries. If by the 6th month you say, I've tried, it's been 6 months, I haven't been able to locate a single thing about them. They've just disappeared from the earth. And you hear about stories like this as well, and they come back and these people make a claim, and they can, but it's important for the executor to know that you may be liable. If they make a claim and take it to court, they may actually be successful. Because let's say they said, oh, I was a recluse in Iceland or something, like I was around, I just wasn't on social media. And so you need to be prepared to take that risk. So it's up to them if they want to take it themselves, the executor in Iceland, put it in an interest-bearing account maybe. But like I said, how long's reasonable? 10 years is a long time. You'd think that you're not going to find them in 10 years.
So just keep the records of everything you do around the administration, and when it's finished, pop it in a shoebox and leave it just in case.
Correct. Because reasonably, the law doesn't expect you after 6 months and you've done everything. So you've done your final taxation return for the estate. Then I don't want to say your role's ended, because sometimes, shares or other assets might pop up later on in life that you didn't know about, and you have to attend to that. You can't say, oh, I finished it 3 years ago. It's not me. You have to attend to that. It's an ongoing role and responsibility.
So we'll get out of the rabbit hole that I've dug for us, and we'll go back to probate itself. Well, I think we've covered a bit of this already, but so the mechanics around probate are quite interesting to me. So somebody passes away, I have a suspicion I'm the executor or I'm the next of kin, so I hunt around and I find the will. I presume it's somewhere. What do I do next?
Yep, so you find the will. The first thing to do is contact a solicitor, but in terms of the administrative tasks, what you do next is find out their assets and liabilities. So checklist, assets and liabilities that they had at the date of death. Find the original will, because most people will find a copy of the will, and it might not even be the latest will. So make inquiries about where the original will is. Usually it's kept at a law firm, so you can contact, the people that prepare that copy of the will that you have, to make inquiries. And then to get started, I'll start advertising as soon as possible, to get the ball rolling.
Now, you're not bound to go to the lawyer who made the will, are you?
Correct, that's right. You can go to any law firm that does wills and estates, and they can seek probate of that will as well.
So contact them, arrange a meeting, sit down with them, and have the will itself. The assets and liabilities piece, in my experience, can be quite challenging because in my experience as an advisor, very few people keep a detailed accounting of what they have. They should, but very few do. So assets and liabilities, we're talking assets, we're talking about the family home, vehicles, bank accounts, shareholdings, companies they might be running, businesses they might be involved in, collectibles.
Collectibles, yes, if they're worth certain amount of value.
Gotcha.
So the law about actually just recently changed. It's very interesting you said that. So people used to put down, for example, maybe jewelry or antique furniture and say, I think it's worth about 20,000. Give a ballpark, and that used to be okay. But now the Supreme Court requires a valuation and who it was valued by. They want to know now because I think maybe previously people may have just been inflating things, maybe,
Suppressing things
or not.
as well,
Yeah, exactly. So it has to be worth a significant amount, artwork even, significant amount of value, and it has to be valued.
Oh, wow. Yeah, I guess, I put in the probate application, Dad's collection of coins was worth about $300. I'll take that as part of my distribution, and it's worth 50 grand. Yeah, that makes sense.
That's right.
So anything significant or substantial should be valued independently, and that's new. Okay, I didn't know that. General household contents, though, that's kind of just divvied up amongst the family.
So what happens with general household contents, that's usually not included in the probate application, and it's completely is up to the executor how they want to deal with it. So if some of the beneficiaries want to take it and they all get along, this is like
that's the
perfect scenario.
The overriding
That's the key. Everyone gets along and, they can come in and take what they like, then that's fine. Otherwise, it's completely up to the executive. They don't have an obligation to sell it on Facebook Marketplace and make money from it. They can just hire someone to come and clean out the house if they want to. They have a bit of freedom with that. They have to act in the best interest of the beneficiary. So if there is a $50,000 antique chair, and they've just taken it to the dump, and then a beneficiary comes on later and says, well, you actually could have sold that. Yeah, you have to act in the best interest. You can't be an executor that just doesn't care and scrapes by.
I think one of my minor interests is in hoarding as a characteristic that people have. And I think that's growing, and I suspect that's going to make that aspect of things even a little bit more challenging along the way too. I know some of the deceased estate cleaning houses, like some of the work they're having to do now to clean out premises is just next level. It's going to make some of that quite contentious, I imagine.
Absolutely. We've had a few hoarders, deceased estates where the deceased was a hoarder. And speaking to the executors, and they're going through and they're like, oh, there's just junk everywhere. But I always say, go through it. You never know what money you will find. Usually it's random money somewhere.
I had a client once, they told me they cleaned out their mother's house, and their mother was in her 90s. And I think she might have been a post-war immigrant from Europe. And they said, we found $60,000 of cash just around the house, tucked into books, in the freezer. There was a can buried in the backyard. So be very thorough in your search of the house.
Right, be very thorough before you hire someone to come and take everything to the tip. Definitely take a look. And so with those hoarders, that's what they've done. They've hired someone. And then you have to be reasonable as well. I mean, it's a huge task for the executor to go through every single cranny in the house. And it takes ages. It takes absolutely ages to clean. As long as they're careful and they let the beneficiaries know this is what we're doing. We're just going to get someone to come. If you want to come and take something, come and take something. Otherwise, it's all going to go.
I think if you're a beneficiary only listening to this and you're not an executive, you've got some doubts around the way it's being done. I mean, my first port of call is assume best intentions, hopefully. But if not, you have some rights. And you actually have quite a few rights as a beneficiary. And you have quite a lot of leverage in that discussion. But returning back to the property side, so what assets, collectibles, is there a search you need to do, because you may not know what mum or dad owned property-wise, like houses? Is there a way you can search for that kind of information?
Yeah, correct. Most conveyancers or a lawyer will be able to assist you with that. It's a paid search, though. It is through a platform. So you might just have to seek around. There's a small fee to be paid for it. And you can do what you call an issue search. So you just type up the person's name and it shows you all the property that they own. And I think the key thing, just taking us a little bit back about assets and liabilities, one key thing that I think really gets people is the value of these at the date of death. So you might know that like mum and dad had a bank account or I don't know, shares, but you need the value at the date of death. And that's tricky. That's when it gets tricky because people don't know what's in someone's bank account, 2 days ago or a month or a year ago. So, yeah.
So it's
yeah,
another reason why you definitely need to have probate so you can make those inquiries. Because, I mean, good luck making those
Correct.
inquiries to a bank when you don't have probate. I mean, it's hard enough when you have probate.
That's right. Exactly right.
Would that
Exactly
issue search
right.
have anything about the debts or just the assets?
No, just assets. So the advertising period, that's supposed to be when creditors can come forward. Most people have liability. The most common liability someone will have are probably a mortgage or credit card debts. They're the most common ones. Sometimes you may have some obscure ones. I haven't really seen any, to be honest. Those are the most common ones. I never, like I said, only had one time one person come forward and say they owed money, and that was a government agency. So,
This is a potentially big question. It might be the wrong question. And we have an episode coming up where we'll have 2 tax accountants on, so we'll talk about it then. But what about if they owe money to a company that they run or a trust that they're a part of? So they have a director's loan or a trustee loan. Sorry, a beneficiary
correct,
loan.
that is a liability. Yeah, absolutely right. That's a liability that goes on the probate application. So it will be a debt that is owed to the various trust or company. That's right, it's included. So that's when you need to be careful, right, as an executor, because first step's obviously you're going to sign this probate application, and then if you see there's more liabilities than assets, do you really want to act and take on these liabilities?
Yeah.
And will they be called upon? That's the next thing as well. Obviously, people will have to have discussions with their accountants and and figure out tax benefits and what's going to happen.
And there are consequences to this. And this again,
There's
just a really broken
consequences,
record. Get specialist advice because forgiving the debt can have tax consequences. Repaying the debt can have tax consequences. You need to know what you're
correct.
looking at.
That's right. And can the estate afford to pay back the debt? And vice versa as well. Sometimes actually the deceased is owed money by the family trust and by a company. So, and that goes in the application too. And that's also something you need to discuss. Are we getting this money? Like it's on the books. So, and that's when we need to speak to an accountant.
That's very serious discussion because you've got many downstream effects. And I think I see in my work, we see structures and strategies deployed that are really, really effective for this tax year. But we're looking at it 5 tax years later. I'm like, you are in all sorts of trouble now. Like undoing this is going to cost you far more tax than your clever little strategy 5 years ago did. So definitely seek specialist advice. You definitely want people that have experience in this kind of area, be it accountants, financial advisors, definitely solicitors. I don't know if there's any complexity. If you've got a family trust, a self-managed super fund, or a company, you need a specialist. You can't go with a generalist, I think. Not to offend all the generalists, but I think you need to go down that path there. What happens? I filled out the probate application, which I imagine is on the Supreme Court website, is it?
So that's correct. So you start completing it on the Supreme Court website. That's right. And you submit it on the Supreme Court website.
Fill it out. By some miraculous reason, I managed to get it all completely right first go, and it's accepted, and I get probate granted. And 6 months later, I find out Mum actually bought a house 5 years ago that I wasn't aware of, or she bought just a collection of cars somewhere or something that I just honestly, despite my best inquiries, I did not know about. What should I do in that event? Can I amend the probate, or how do I do it?
That's right. So if it's a very significant asset, you should probably amend and you can resubmit your probate application. Obviously, that will restart the 6-month period. But that's to cover all base. Yeah, so that's to cover all base because the date of the grants will be different now. So it'll be the same, but it'll be a different date because they would have granted it based on obviously your inventory. So it's called inventory of assets and liabilities. Yeah, that you've submitted. So definitely you can amend. Some situations though, so we've actually had that situation occur and it was actually a disputed estate. And we later on found out there was just incorrect instructions. We thought the deceased owned the property jointly with his sister. It turns out that he didn't. He owned it in his sole name and it was missed. It was just missed. because the sister and the mum had the same name.
Oh, God. Okay.
So there was just confusion. There was absolute, and the sister kept saying, "Yes, it's my property, it's my property." But then it turns out it was actually owned with the mum, who predeceased the deceased.
Ooh.
So yeah, so by the laws of survivorship, it went to the deceased in his sole name, so it owned it solely. So completely missed. Um, and with that though, and it was a disputed estate, but we just said, honestly, look, it was missed. We were honest to all the beneficiaries, all their lawyers, and it was fine. Nothing actually came out of that. They didn't, it's not a requirement and necessity to go and refile a new list of inventory of assets and liabilities. But sometimes if you have a disputed estate, it might be in the best interest to do that to protect yourself. But in here, everyone was represented, and I think everyone felt, oh no, they weren't trying to hide an asset.
Represented, you mean everybody had legal assistance?
Legal representation. Everyone had every beneficiary had a lawyer.
So it's a much more robust arrangement then. There's a lot more security around it.
Correct. And we were honest and we explained our circumstances. So that's what I say. If you're doing it on your own, I recommend refiling, but seek legal advice. It depends. It's very circumstantial.
You said the word substantial, circumstantial, discern, reasonable. I love, in my line of work, my cohort of people, we're mad for having strictly defined thresholds. Okay, 49,000 is not substantial, 50,000 is. But in the legal world, which, that's just not the case. Like, you need to make a judgment call as a reasonable person as to what would be substantial and circumstantial. And I think that's where a lot of the nuance comes in that maybe throws some more mechanically minded people, or quantification minded people. So it's just, each case is very different, and you need to be very aware of that, I think.
Correct. That's right. Every circumstance, every probate circumstance of a family dynamic, very different. Circumstances may maybe be the same. For example, like mum and dad passes and you're a child. That might be similar.
On surface level,
but
sounds easy.
Exactly. On the surface level, sounds absolutely easy. But then when you go underneath and deal with different layers, there's just so much differences, and it's very, very circumstantial how you're going to handle the matter. And sometimes from the start, if we've seen there's been a potential problem, even before getting probate, we've written to another side or to the beneficiaries, making them aware that we've been engaged, and also suggesting a mediation, because we've heard about the family history, and if we go down this path, legal fees are being wasted because the beneficiaries don't trust the executor doesn't like the benefit, and the siblings most of the time. Most of the time, this is an example. And so sometimes, making that commercial decision to say, hey, we're going to have a discussion, roundtable discussion with everyone. We're going to explain that, there's a lawyer involved. We're independent. We're not part of your family drama. And our interest is making sure that the deceased wishes through their last will is done.
I think that's just to go back to that idea of it's a very difficult job for you guys. Hang on, no, I won't completely absolve the legal profession. Most good lawyers are there to hold your hand and help you navigate through this storm and get to the other side and get it done. The exceptions are the ones that maybe drag it out, but they're the bad guys. We don't talk about them. The good ones that's their job. So they are independent and they're trying to get you through this process as quickly and as painlessly as possible. They're not the enemy, is what I'm trying to say.
That's right. That's right.
A thought just popped into my mind. Do offshore assets and liabilities make probate more difficult?
110%.
I don't know why.
Yes, I just, this matter just came into my mind when you said that. Absolutely.
They're treated the same. You still pop them on the inventory, I assume. Does the challenge come from valuations and access?
Definitely. So it's because now you're dealing with different. Well, I'll use America as an example because we tend to deal with America quite a bit. So you have to go by their requirements, obviously. So you write to them, say, this person's died, death certificate. This is our grant. Showing that this is the executor. What do you need? Like, what can we do to close this account? And they'll tell us their requirements, but it is tricky. It is absolutely tricky because, like I say, they might not accept a grant of probate. They might want a letter from the executor giving them authority, first of all, to speak to us, which is fine, but sometimes they require it in wet ink. They only do post. They don't email. They don't do EFT transfers. They only issue checks.
Oh, God.
That's right. It's problem on problems on problems. I mean, it's no one's fault, you know. It's absolutely no. This is just how it is. But having offshore assets is quite difficult, and America, as it is quite you know, it's a Western world, but we've had sometimes had to write to what's it called, Bali, and that's
Oh, right. Yes, yes, yes. So the jurisdiction, I mean, there's a lot of overlap with the jurisdictional approach with like America or
yeah,
England or something like that. But you go outside that kind of
yeah.
Western dynamic.
Correct. It gets even more tricky. There might not be records kept. There might not be. And then sometimes we've had in the past an executive make a decision to not pursue an asset just because the cost of pursuing it or even the attempts to do it, just outweighs the benefits. And they've consented with all the beneficiaries and we have it all written down. It's just too difficult because there'll be a lot of back and forth, a lot of time wasting. Yeah, it's just, it depends. Circumstantial. It's always
It depends.
circumstantial. It
The
depends.
professional
It's
motto,
very
the answer to every question. It depends.
depends. But it's difficult. I'm not gonna lie. No matter America, Bali, Vietnam, it's actually, it is difficult.
Uh,
Can be
I
done
think
though.
that's when you know you're dealing with a professional when they say it depends. It's when they have really clear answers for everything. That's when you should be a little bit suspicious. It should be it depends.
Yeah, it really depends on
So I
your
think we've answered it,
perspective.
and I suspect we've scared everyone away from the idea. But in theory, can a person obtain probate on their own?
Yes, they can. Absolutely, they can. Everything can be done on your own. The whole process, you can do it on your own. The issue is if you don't do it correctly. So, for example, you put in you or you submit your probate application to the Supreme Court. They review it, and then based on that application, they say yes, here's probate, or they make their inquiries. Where people might struggle is if they haven't done the process correctly. So, for example, if you haven't advertised, you might not know that you had to advertise. So you've just gone ahead and made your probate application and filed it with the court. The court's going to reject you and say you need to go back and advertise. Also, that application needs to be completed correctly. There's certain, I guess you can say, legal jargon that needs to be written there in the probate application as well. But don't get me wrong, you definitely can do it yourself. If you don't get it through, the court's pretty good because they'll tell you exactly why they haven't accepted your application and what you need to go and do.
And they can't give you
But
advice around that. They can just say factually, here's what's been missed. We cannot accept it like
correct,
this. So is there a scenario where I
correct.
put in the application, it's rejected, I amend it, I pop it in, and that can go back and forth, back and forth, back and forth? I mean, potentially forever. Is that fair to say?
That's absolutely right. That's right. And it causes even more problems if the original will, the original will needs to be a document that's kept intact and really, really looked after. If it's been stapled and then unstapled, and if it's been written on, it causes even more problems. And the court's going to say, prove that this is the original will. How are you going to prove that? You know it's original, but how are
So
you
do you have
going
to
to
lodge the
prove that?
physical copy of the will? No, sorry, the physical
Correct.
original of the will?
Yes. So it's not lodged. That one is actually posted to the Supreme Court.
Whoa.
So yeah. So it gets posted to the Supreme Court, and they actually look at it. That's why. And then if it's all good, they'll grant it. If not, they'll come back with questions. So I've had in the past even, the deceased took the original will from their solicitors once it was prepared and they signed it. So they don't forget, they wrote the word original at the front of their will. Understandable, understandable. And then they stapled it. And then in during their lifetime, for whatever reason, they've made copies of their will. So they've unstapled it, made copies, restapled it in different spots. And that was difficult to get it through.
The
We
stapling
got
is
it
something
through.
that I find, just from an external observation, I find it, first I found it really annoying, and now I find it kind of almost funny. How much effort goes into reviewing the staple holes? Because the reason,
Yes.
my understanding, and correct me if I'm wrong, but my understanding is the reason they check that so closely is it can signify pages being added or removed. It can signify that the original has been tampered with in some way. So they literally do go to that corner where the staples are and say, okay, how many different staple holes are there?
That's right. That's absolutely right. And it's for those reasons that you said as well. Like we had a deceased who was blind, and when she signed her will, she was just no reason at all. She was just shaking and old. That's all it is. But they reviewed it and then said, why was it shaking? And I don't know how you can tell that from someone. Maybe it wasn't very clear, but they said it, and you have to file. And so someone who might be doing it on their own might not know how to approach those questions. Especially, I think the hardest is when the court rejects it based on capacity. That might be a bit difficult if you're on your own and they say prove that the person had capacity. You wouldn't know where to start. You also have to prove them in the forms of affidavits. So that's also something that might be a bit difficult, and it's worth seeking legal professional advice.
An affidavit, for people listening, that's a court-reviewed sworn document. Like that's testimony in written form, basically, isn't it?
Correct, exactly right, correct. That you make and you believe to be true and correct based on, whatever circumstances. And if they don't have a capacity, the doctor, their medical treating GP, makes an affidavit and swears one saying that they had capacity at the time of executing their will.
We're not mucking around. This is a serious thing. This is a serious document.
100%.
If anybody is bold enough to go down this path on their own, do you have kind of any easy tips or ideas or things to watch out for that they should keep in mind?
Yeah, no worries. What I'd actually suggest, and this has happened quite a few times, is do have a solicitor that you do check in with. So what I'd suggest is the first go and see a solicitor about what you need to do so that you do have the right processes and you're not just guessing. The Supreme Court website helps a little bit, and it tells you about the necessary forms you need to fill out, but it can, I guess, it's not in depth either.
I'm thinking about the Scanlan equivalent as like that can help as well. Like if you wanted to sit there and do it, like you.
Yeah, that's right. Yeah, that's exactly right. So I recommend having an initial meeting with the solicitor so that you understand what you have to do. You might decide that I'm going to try it myself, but then later on it's not working. So you can go back to your solicitor and they can assist you. Usually most people engage a solicitor at least to get a grant of probate, so that at least that process is done properly. And then after that, once you have the certificate, if you want to go and close bank accounts on your own and do everything else on your own, you're more than welcome. No one's stopping you. You don't have to have a solicitor. It's just done more efficiently if there is a solicitor involved, and it's done more quickly. So that's why people engage a solicitor. But I understand a lot of people want to save legal fees, and they might want to do it on their own, especially beneficiary distributions as well. I've had a lot of people say, oh, we want to distribute because we want to make it more personal. We want to say, oh, this is what dad or mum would have wanted. Thank you for knowing them. So I've had people say that, like they don't just want a lawyer to contact them and say, you're a beneficiary, what's your bank account details? They want to have a chat.
I hadn't thought of that.
Yeah,
so a lot of people for having the money actually distributed.
Yeah, so how it works usually is that all the funds are kept in a solicitor's trust account, and that's another thing as well. When you go off and close bank accounts, they won't distribute to any bank account. It's either a solicitor's trust account or an account in the deceased name in a state of a trust account. So you will have to go and make one if you are not using a solicitor as well.
And I think the point to revisit there, on a previous episode, we talked about that administration piece, and you want it to be in a new bank account, not the old deceased's bank account, because that's when the banks get their fingers a bit sticky. You want to have it in a new estate of account.
Correct, that's right, because those accounts are going to close. They'll be frozen and they'll be closed. So there'll be no access to them anymore. So usually everything's kept in that solicitor's trust account, and then at the end, once tax is done, so at the very, very end, we distribute to the beneficiaries in accordance with the will, pay out the gifts, everything like that. But I know that some people, and I've had some executors, say in the past, do you mind, like, before you distribute, we make contact with, the various charities or some beneficiaries that may have not been expecting to get anything, just to make it a bit more personal, to say, oh, how did you know mum or dad, or thank you for helping them throughout their life, or if it's a specific charity and it means a lot to them, they want to reach out and say something. And then once it's all good, like, we'll pay the money, but they've had that contact or make that email.
I think it's a really good addition to the process. And I would flag, I think that would be quite meaningful for the executor or the beneficiaries to be doing that contact. That's quite nice. And then they let you know, and then your office calls and says, hello, I'm calling from Scanlan Carroll. What are your bank details because you are a beneficiary of so-and-so's will?
Correct. That's right. And it's a very, very commercial transaction.
Mm.
That's right. I'm just paying out to whoever. But I think, especially charities, I think charities are very, very grateful, especially if the deceased was a long time,
Mm.
donator. They write some very, very nice stuff. I've had people make donations and I've had awards named after them.
Mm.
Um, yeah, things like that. Very, very nice things. So
Which was just a
it's
transaction
worth.
on their bank account. It doesn't have the same impact. I can see that. That's a nice addition.
Yeah, yeah. So definitely something to consider as well.
Um, Gillian, I think we've covered so much ground. It's been really, really enjoyable. It's been fascinating. With this series, I mean, we learn kind of the very broad concepts through my work, but the nitty gritty day to day stuff that you guys do fascinates me. Like even that idea then of the personal contact, I never would have thought of that, but it's such a great idea. I think if things are amicable. So thank you so much
Yeah.
for coming on and sharing that information and that detail with us, because I think yes, people can do it themselves. I wouldn't. I mean, hearing all these stories, there's no way I would do it myself. Um, so thank you again. Were there any kind of final words you wanted to add, and how can people get in contact with you if they have any questions?
Yeah, no worries. I guess my final parting words, if anything, is do not leave things up to chance. I usually use this little anecdote where if you're going on a holiday, right, you pre-book everything. You plan where you're going to stay, you plan your activities, you look at the weather even. Everything is planned in advance. No one will just go on a holiday and just pray for the best, not book accommodation, just say whatever happens, happens. I think that's the same with your life.
Mm,
You want to plan in advance. You don't want to take a risk. And contacting a good estate planning lawyer can definitely assist with that.
because I think even
Because
to sort of hijack that, sorry, but with the holiday idea, you're almost buying a holiday for your family and just not planning anything for them, and they will just find themselves in some foreign locale, and then they have to work it out.
that's right. That's absolutely right. Yeah. You're just creating more ambiguity. Sorry. So definitely, get your wills and estate planning done. The sooner the better. I know people don't like to think about
Mm,
it. They think they'll manifest their own death or something like that. It's not like that at all. It is a bit of a dark topic, but it's an important topic that needs to be
completely agreed.
spoken about.
Absolutely.
Yeah,
And
yeah.
how can people get in touch? Because I think people might have some questions or they might want to have a chat. What's the best way to reach you?
Yes, please. So, Scanlan Carroll Lawyer. So, we're located in Kew. And the best way to get in contact with me is my email. So, it's Gillian with the Gillian at scanlancarroll.com.au.
Fantastic. And things will be linked in the show notes as well. So, Gillian, thank you so much. I really appreciated your time and expertise on that. So, thank you. And for everybody listening, thank you again for listening to Life, Loss and Legacy, a Planning Solo podcast. As always, if you have any questions, reach out, Jordan at planningsolo.com.au. Otherwise, we will speak to you soon and see you in the next episode. Thanks a lot.
Thank you. Thanks, Jordan.